All rise. This Court of Appeals is now in session. The Honorable Jennifer Hensel presiding.
Good morning. Please be seated. It's good to say that again after all this time. The first case to come before us this morning is In Re GG. It's my understanding that the agency has waived oral argument. You will have 15 minutes to present oral argument. Come on up to the podium. Please don't use the names of any victims or minors during your argument this morning, as we are recording and we'll be posting on YouTube today's oral argument.
Thank you.
We have read the briefs and we're ready to proceed when you are.
Thank you, Mayor. Please the court. I'm Barbara Rogoshevsky. I represent the appellant Shamar Galvin, and it's good to be back. Public policy favors the finality of judgments. The double jeopardy clause of the U.S. Constitution states that you can't be tried for the same crime twice. You also can't be required to litigate the same civil case twice under the Doctrine of res Judicata, which has its roots in the 7th Amendment of the U.S. Constitution. Therefore, no one in the United States, certainly in Summit County, should have to defend themselves in the same case with the same claims and the same issues twice, unless you're involved in a children's services case. Consider a situation in which a family finds themselves in juvenile court because Summit County Children's Services files a complaint for neglect, dependency, or abuse against a family of 4 children in February 2020. Subsequent to that filing, Summit County Children's Services obtains emergency temporary custody in April 2020. The case comes to adjudication on August 4th, 2020, and following a full adjudication, the court dismisses the complaint as having failed to meet the requisite legal burden to sustain the claim. That decision is issued August 7th, 2020. August 10th, 2020, 3 days later, Summit County Children's Services files another complaint regarding the same 4 children, involving the same mother, the same fathers. And the only reason that there is a 3-day gap between the dismissal and the refiling is because the dismissal is issued on Friday the 7th and the refiling is Monday the 10th. And then the case comes to adjudication again in November 2020. And following a full adjudication, the court again dismisses the case against the oldest 3 children, but finds the youngest child to be dependent. And in that trial, there is testimony taken about evidence and situations dating all the way back to November of 2019, a full year prior. Situations and evidence that include the time period of the first case that was dismissed on August 7th. After the adjudication is concluded, the court issues its decision. Both sides file objections. Mother files objections, objecting to the adjudication that the youngest child, who at that point is approximately 10 months old, 11 months old, is dependent, and filing an objection to the fact that the child is placed in the emergency temporary custody, the temporary custody of Children's Services, while she's in fact been in their temporary custody since April of 2020. Also objecting to the fact that the case is res Judicata, because we've been here before on these issues, on these claims, with with these people. Summit County Children's Services, they also filed an objection as to the oldest 3 children for the reason that the case is dismissed. A few months later, the court, in this case in Ray GG, sustains the court's original finding that the child is dependent, overrules the objections, but in their decision never addresses the issue of res judicata. The words never appear in the judgment entry. It just simply isn't addressed. As to the oldest 3 children, the court overrules the objection. So the children are not adjudicated to be dependent, neglected, or abused a second time. But wait, they file a 3rd time on the oldest 3. And there is a 3rd adjudication on the oldest 3 children a few months later. And every time Summit County Children's Services refiles their case, they file for emergency temporary custody and Latino. So the children remain in custody with the agency in foster care. A 3rd adjudication is held on the oldest 3 children, and a 3rd time the agency's complaint is dismissed for lack of evidence. And at that point, the children, the oldest 3 children and the youngest child have all been in the agency's custody now for a year. The oldest 3 children never have been adjudicated dependent, neglected, or abused. Sound kind of unusual, far-fetched? No. It's exactly what's happening to this family. This agency has used the opportunity to have its own court and the ability to refile this case over and over and over again to continue to make the same claims, to keep this family mired in the system. This is the very definition of res judicata. Now, it is very tempting to argue, well, this is a child welfare case. We don't want to endanger children. If there's a risk to these children, we have to allow the court to investigate that risk. Nobody wants to see children put at risk. But that's a paper tiger. If we do that, we can simply say, well, let's throw out the double jeopardy clause of the U.S. Constitution. Because after all, if an alleged rapist goes to trial and they're acquitted, some people may think there's a rapist going free. Or let's throw out suppression hearings altogether. Because we want all that evidence, right? We want it to come into trial because we want to adjudicate whether somebody has in fact broken the law. But we routinely suppress evidence when the Fourth Amendment requires it, because we have to follow the law.
Counsel, isn't this a little bit different though, because in these situations, it's so contextual, and it's basically a moving part. I hate to say it like that, but it's just constantly on a string of change and so forth. And so if something new happens, can't you consider everything that's happened before in the context of the new incident?
Well, res judicata says that a claim, once fully litigated, cannot be refiled. So if we're looking, I think the difference here is we look at, well, during this time period, a parent may have used drugs again or obtained a new warrant, which was the allegation here. All the way through this case, there have been basically certain claims. One claim is of substance abuse. Now, we can have additional examples of substance abuse, but the issue is substance abuse. And if that's a fully litigated claim, then it's a fully litigated claim. And 3 days later, it doesn't suddenly become a whole new situation that needs new context. I think especially in this case, because in this case, these parents were without custody of these children for months prior to the adjudication on August 4th. And then August 7th, mother had, quote, custody per se, but they didn't actually come back to her ever. So what new situation could have arisen during that time certainly didn't come out in the transcript in this case. As a matter of fact, in the transcript, the caseworker specifically acknowledged that between August 7th and August 10th, when the new case was filed, the children were not even in mother's physical possession. And no new situation, when we're talking about situational issues or moving parts, no new situation arose that caused the filing of the August 10th complaint. So if in this case it might be a little unusual, I think it's a very stark example of the fact that the agency simply refiled because they didn't want to lose, not because there was a new claim or a new issue that needed to be litigated that was separate and distinct from the previous complaint. What's interesting in this case is we don't need to make new law. We don't need to interpret law. All we need to do is follow the law. What we need to do is tell the trial court and the children's services that they're just, the children's services just like any other litigant. If they file a case and they have a full and fair adjudication of their claim, then they can't refile the same case again and again and again. To keep a family trapped in the system just because they don't want to lose their case. That doesn't mean that should a family ever need to come to the attention of the agency again for a whole new claim, a whole new set of issues, that bars the agency from forever addressing it. But I think in this case, 3 days, I think anyone would agree in 3 days. With the testimony we have in this case, that simply wasn't what happened here. And it's especially disturbing because Children's Services has so much power as a government agency. Once they obtain temporary custody of a child, they can place them in a new school district, obtain medical care that the parents may not necessarily know about in real time, or agree with or consent to, place them in certain types of therapies without the parents' consent. I mean, they have a whole host of rights. And to be exercising those rights over the course of a year or 6 months without ever adjudicating a child to be dependent, neglected, or abused is a huge abuse of power. And it will continue to happen if it's not addressed here. I have a few minutes left. Are there any questions about that issue?
Seeing none?
I briefly want to address the issue of the objections, and the objections that were not even referenced in the judgment entry in this case. As this court is aware, the cases out of this court make it very clear. Benning v. Benning, PNC versus Myers. The court is required to make an independent review of all issues brought to the court's attention in the objection. That doesn't mean there has to be a talismanic boilerplate set of words, but they have to acknowledge that they've reviewed it, take an independent analysis, and then rule upon it. In this case, the court went into a fairly detailed recitation of why the court believed that this particular child was dependent, which we disagree with, but that is briefed fully, I believe. And I believe it, and again, ropes back into the res judicata issue. But what the court didn't do is they never even mentioned that we objected on the basis of res judicata, that this couldn't even be brought to trial a second time.
Counsel, the court didn't mention also specifically the arguments, any of the objections. It looks like it did like a complete de novo review, but it doesn't mention the particular specific objections, it just says objections overruled. So does that matter? Does that make a difference? Because it seems like in the case law where we've had a problem with that is whenever they mention like 2 out of the 3, but don't mention a third one.
I think in this case, the court conducted a pretty, while they didn't say litigant objects on these 3 bases, 1, 2, 3, and then addresses them specifically, I think the court in this case went through a fairly detailed recitation of why our objection to the finding of dependency, why the court overruled that objection. While they did not talismanically say there's these 3 objections, we're addressing them 1, 2, 3, I think the court well addressed 2 of our objections. Maybe we didn't love the outcome, but I think they addressed it. But the court never ever got it, even addressed the issue of the fact that we brought up that this adjudication was res judicata. And therefore, the court didn't even have the authority to have a second adjudication or to entertain a second complaint on this basis. So that I don't think was even addressed at all. And I think that's the difference.
Counsel, I need to know that we need to let you know that you've utilized your time for oral argument this morning. Thank you very much for your presentation today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on the Ohio Supreme Court website.
Thank you very much.
Thank